Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of criminal procedure, negotiable instruments and service law. To know more about them, please watch the video fully. In the important judgment titled KAMLA Devi versus State of Rajasthan and another, pronounced on 11th March 2022, the Supreme Court has held that a court deciding a bail application cannot completely divorce its decision from material aspects of the case. The facts of the case would be that the charge sheet was filed against the respondents, the accused, under sections 302, 201 and 34 of the IPC. The matter was committed to the court of the additional session judge for trial. The accused preferred separate applications seeking bail under section 439 of the CRPC and the same were rejected. Thereafter, the accused were before the Rajasthan High Court and by the impugned orders, the High Court enlarged them on bail. Being aggrieved, the appellant, the wife of the deceased, preferred the present appeals with allegation that the High Court failed to consider the severity of the offences alleged against the accused and the brutal manner in which the offences were committed and attempted to be concealed by throwing the body of the deceased together with the murder weapons into a well. The Supreme Court has held that the primary considerations which must be placed at balance while deciding the grant of bail are the seriousness of the offence, the likelihood of the accused fleeing from justice, the impact of release of the accused on the prosecution witnesses, likelihood of the accused tampering with evidence. If a court takes into account such factors in deciding a bail application, it could be concluded that the decision has resulted from a judicious exercise of its discretion. Also, an order granting bail to an accused, if passed in a casual and cryptic manner, dehawks reasoning which would validate the grant of bail is liable to be set aside by this court while exercising jurisdiction under Article 136 of the Constitution of India. Further, the court deciding a bail application cannot completely divorce its decision from material aspects of the case, such as the allegations made against the accused, severity of the punishment if the allegations are proved beyond reasonable doubt, which would result in a conviction, reasonable apprehension of the witnesses being influenced by the accused, tampering of the evidence, the frivolity in the case of the prosecution, criminal antecedents of the accused, and a prima facie satisfaction of the court in support of the charge against the accused. The offences alleged against the accused are of grave nature. It is also the case of the appellant that following the release of the accused, namely Kishan Singh, on bail, he threatened the appellant with dire consequences for pursuing the alleged criminal trial. A complaint in that regard also was filed against Kishan Singh. Thus, the possibility of the accused threatening or otherwise influencing the witnesses, if on bail, cannot be ruled out. The post-mortem report, when considered in its entirety, is suggestive of the fact that the deceased was murdered. Although the cause of death is recorded as cardiopulmonary arrest due to asphyxia and venous congestion, the hyoid bone of the deceased appeared to be fractured. Therefore, this court is not inclined to hold that the prosecution has not established a prima facie case as to the guilt of the accused. The bail applications preferred by the accused before the additional session judge were rejected, having regard to the gravity of the offences alleged. However, the High Court granted bail by passing a very cryptic and casual order, dehawks cogent reasoning. Therefore, the High Court was not right in allowing the bail applications. Hence, the impugned orders are set aside. Coming to the next important judgment, titled M. Kendra Devi versus Government of Tamil Nadu and others, pronounced on 10th March 2022. In this judgment, the Supreme Court has strongly deprecated the practice of the state of Tamil Nadu in making compassionate appointments to Group B post in violation of the 1994 judgment in the case of Umesh Kumar Nagpal versus State of Haryana and others, 1994 4 SCC 138, which held that compassionate appointments must be restricted to Class 3 or Class 4 or Group C or Group D posts. The facts of the case would be that the petitioners, who are direct recruits, challenged the seniority given to those appointed through compassionate appointments. The single judge dismissed the writ petitions, citing the belated stage of challenge to seniority. On appeal, the division bench, though expressed anguish at the fact that compassionate appointments were made to a Group B post in violation of the 1994 judgment, declined interference. Being agreed, the present appeals have been filed with an issue posed for consideration, and that is whether assistant engineers who were appointed through compassionate appointment could claim seniority over those appointed through direct recruitment. The Supreme Court has held that the post of assistant engineer is in Class 2 category, and as per the scheme of the Tamil Nadu State and Subordinate Service Rules 1955, it is to be filled by direct recruitment or through recruitment by transfer, whereas the compassionate appointment is an exception to the general rule of public employment through open selection in conformity of Articles 14 and 16 of the Constitution, and the object of granting compassionate appointment is to enable the family to tide over certain crises and to grant relief to the family against financial destitution who have lost their breadwinner. The compassionate appointments are invariably made looking to the eligibility of the dependent seeking employment and the post held by the deceased who was the member of the service, and this court can take a judicial notice that appointments were earlier made in Class 2 posts which are under purview of the Commission, and that was the reason for which this court in 1994 judgment came heavily while holding that compassionate appointment is not a vested right, and held that such appointments shall be restricted to the post in Class 3 and Class 4 with an object to give a relief to the family of the deceased from financial destitution who suddenly lost their breadwinner and to help it to get over the emergency. So the compassionate appointments made on the post of assistant engineer after the 1994 judgment were deharsed the 1994 judgment. At the same time, the alleged compassionate appointments were made pursuant to GO dated 20th May 1981, wherein it was mentioned that such compassionate appointments shall be on ad hoc basis just to overcome the financial crisis because the family lost their breadwinner, and such incumbent has to qualify and undergo the process of regular selection to be held by the Commission. But later, by GO dated 16th July 1993, the stipulation of qualifying to hold the post after selection to become member of service was deleted. In consequence thereof, all such earlier appointments made in Group B made prior to 16th July 1993 stood regularized by a single stroke by the government with effect from 16th July 1993, and later compassionate appointments which were made on the post of assistant engineers, their initial appointment was considered to be the regular appointment for all practical purposes. Neither the GO dated 20th May 1981 nor the one dated 16th July 1993 were the subject matter of challenge, and by the time the question was raised assailing compassionate appointments, such compassionate appointees attain seniority in service for 7 to 12 years. Any adverse comments made at this stage may certainly jeopardize the right and interest of the compassionate appointees who were although beneficiaries but were never at fault. That indeed lies with the state in making compassionate appointments, drs the 1994 judgment. Although this court deprecates the practice of state in making such compassionate appointments after the 1994 judgment, still this court refrained to disturb the seniority list which was assigned to the respondent respective compassionate appointees vis-a-vis direct recruits, assistant engineers to whom consequential seniority was assigned undisputedly under Rule 35AA of Rules 1955, which may not call for interference at this belated stage. Now we are going to deal with the important judgment titled TEDHI SINGH versus Narayan Das MAHANT, pronounced on 7th March 2022. In this judgment, the Supreme Court has held that it cannot be expected of a complainant to initially lead evidence to show that he had financial capacity unless such a case was set up in the reply notice by the accused. The facts of the case would be that the appellant was in urgent need of money, and out of friendship the respondent gave a sum of rupees 7 lakhs and the check given by the appellant was dishonored. The Chief Judicial Magistrate found the appellant guilty of having committed the offence under Section 138 of the Negotiable Instruments Act 1881, and the same was affirmed by the Sessions Judge. The revision filed by the appellant was also dismissed by the Himachal Pradesh High Court. Being aggrieved, the present appeal has been filed with allegation that this is a case where the High Court as also the two lower courts have not appreciated the law which is laid down in regard to the effect of a probable defence. The counsel for the appellant also pointed out that this is a case where, contrary to the finding of the trial court, a reply notice was in fact given by the appellant as admitted by the complainant. The Supreme Court has held that Section 139 provides that court shall presume the holder of the check received the check of the nature referred to in Section 138 for the discharge in whole or in part of any debt or other liability. This presumption, however, is expressly made subject to the position being proved to the contrary. In other words, it is open to the accused to establish that there is no consideration received. It is in the context of this provision that the theory of probable defense has grown. The principle has developed that all which the accused needs to establish is a probable defense. As to whether a probable defense has been established is a matter to be decided on the facts of each case, on the conspectus of evidence and circumstances that exist. There is some merit in the complaint of counsel for the appellant that the High Court has not appreciated the real purpose of examining DW1 to DW4. She is also correct when she drew the attention to the accounts of the Grameen Bank to show that before 5th of August 2011, the appellant stopped operating the account in the said bank and a very small and ignorable amount alone was available in the said account. The trial court and the first appellate court noted that in the case under Section 138, the complainant need not show in the first instance that he had the capacity. The proceedings under Section 138 is not a civil suit. At the time when the complainant gives his evidence, unless a case is set up in the reply notice to a statutory notice sent that the complainant did not have the wherewithal, it cannot be expected of the complainant to initially lead evidence to show that he had the financial capacity. To that extent, the courts were right. However, the accused has the right to demonstrate that the complainant did not have the capacity, and therefore the case of the accused is acceptable, which he can do by producing independent materials. It is also open to him to establish the very same aspect by pointing to the materials produced by the complainant himself. He can further achieve this result through the cross-examination of the witnesses of the complainant. Ultimately, it becomes the duty of the courts to appreciate the totality of the evidence and then conclude whether the accused has shown that the case of the complainant is in peril for the reason that the accused established a probable defense. But in the reply notice, the appellant has not set up any case that the respondent did not have the financial capacity to advance the loan. Also, at the time when the reply notice was sent, the case is not set up against the loss of checkbook and about the check relied upon by the respondent being one which is brought into existence using the lost signed check leaf. Further, there is no evidence to establish that the appellant informed the bank about the loss of the checkbook containing blank check and the signature of the check was not put by him. Therefore, in the totality of the present case, the appellant has not established a case for interference with the finding of the courts below. The amount of compensation in question has been deposited already in the trial court. However, the appellant should be granted relief in the form of substitution of the sentence of imprisonment of 1 year with a fine. An amount of rupees 5,000 should suffice as substitution for the imprisonment. Apart from that, this court would also direct that a further amount of rupees 15,000 shall be paid as compensation to the respondent.